My name is Richard Parrish. I'm an attorney with the law firm of Fulkerson & Fulkerson in Oklahoma City. I've got a couple of my partner here today, Sean Fulkerson, is here with me in the law firm, and we have one of our paralegals, Angela Sheets, here today. She's the one who's been handing out the packets and is going to pass around a sign-in sheet for anybody that would like to sign and just let us know who is here, give us phone numbers, mark in case you want to indicate. Is this working? Hello?
My part is working, the video.
Your part's working, the video? Oh, okay. Anyway, what I thought we would do this evening, we didn't prepare a big formal presentation, any kind of a big dog and pony show. We came at the request of the Woods County Mineral Owners Association to just answer questions and give you a little background on what's going on. So I thought we would do that. The packet I referenced before, hopefully everybody has a copy that kind of addresses those things. And I thought we'd just kind of walk through that and maybe answer questions and go from there and see who's interested in what's going on, what questions you might have. As we get started here, I'd like to just show of hands to see what kind of crowd we have. Do we have mineral owners, I assume, since it's a mineral owner association? What about people who are just surface owners? Everybody else pretty much owns surface and minerals, probably. Farms, ranches, a combination. Then, of course, the important questions for tonight are, do we have any employees or representatives of Chesapeake here? I figured we would. Do we have any employees or representatives of Sandridge? I figured they would have somebody present, which is okay. Anyway, if you're here, welcome. If not, I'm sorry you're not here. Anyways, everybody gotten a copy of the packet? Have those gotten passed around? Well, let's just take a look at the packet. We'll kind of work our way through it. The first page of the packet has the case style of the case that we've already filed. We filed an action in Woods County. Have a handful of plaintiffs raising issues over the water lines, be it saltwater lines, be it freshwater lines, whatever kind of lines have been laid, running to and from water sources to wells, from wells to disposal sources, whether they're transporting saltwater, mud, drilling mud, freshwater, whatever. The purpose of the suit is to seek compensation from the oil companies for doing that. We'll get more into that in a little bit. It's our position that they don't have the right to be laying these lines. We think the law is pretty solid in Oklahoma on that issue. And the case has been filed as a potential statewide class action. We have not sought certification yet of a class, but we are in the process of preparing a motion to seek to have it certified. We have owners in the lawsuit from two counties at this point, Woods and Alfalfa. I know that the same activity has been going on in a number of other counties, Garfield, Grant. I could probably name about. I drove through some others that I didn't pay attention on the way up here what counties we were in. I should have paid more attention, I guess. Do we have people here from Woods County, I presume, today, being the Woods County Mineral Association? What about Alfalfa County? Anybody from Alfalfa County? Grant County? Couple? Few? Okay. Garfield County or any other counties? Some of you have property in more than one county. Okay. Woodward County. Any other counties? Major County. Okay. Well, so we know the same activity is going on in a lot of counties. I don't know that it's happening in all 77, but it's happening in more counties than not, as it's become prevalent, and oil companies have figured out they can lay these temporary lines, or think they can lay these temporary lines, and save money, which is what oil companies always try to do is they can figure out a cheaper, less expensive way to do it. They'll do it, sometimes at a cost or to over the rights of others. Anyway, the first page, as I said, is the style of the case. The case is pending in Woods County, and we're planning to move it forward. I've listed there our law firm, who is the lead firm on this matter. And it's our intention to start pressing this case forward. We've been talking to landowners. I've been up here and met with some other landowners and persons, local attorneys, both here in Woods County and other counties, with regards to other parties and clients. who may join the lawsuit or come in as part of the class. The next 2 pages in the packet contain some photographs that were taken by some of your local citizens, kind of outlining the problem. You all are probably more familiar with those than I am, but I've made several trips up here, have traveled around the county, viewed some of these lines. Obviously, we photographed these lines. There's a lot more where this came from, but we just kind of included a couple of pages here for your benefit and for our benefit, frankly, so that we continue to remind ourselves of what the problem is and the concerns. You see single lines, multiple lines, lines running through culverts that are potentially going to cause drainage problems. You all have lived that. We're going to move on in a moment to the newspaper article that was previously published, and an article that was published on the NPR radio station out of Norman, KGOU, by an entity called Sudden Impact Oklahoma. There are copies of that attached. They quote extensively in those articles from Randy McMurray, who I've never met. Is Randy here this evening? Okay. Welcome. Ari? McMurphy, I'm sorry. I apologize. Anyway, I think he has been a leader in this area. I think he has taken a position that is correct. It may be politically expedient for some county commissioners or some individuals who don't want to rile the feathers of oil companies, but I think the anecdotal evidence and stories he tells in those articles are true. I know you all know they are true, and give a clear indication of the problems caused by the activities in the oil companies in laying these lines. Besides using your land and not paying for it, the blocking of driveways, the blocking of entrances into pastures, the impact. I guess there have been mailboxes knocked over. There's photographs of some of these things. There's probably other examples of things these lines have caused, damages that we're unaware of, that hopefully more individuals will come forward or we will learn about as we progress. And like I said, those are all indicated, some evidence of that in the photographs and then the articles which are attached. And so I think you all should be thankful that you have a county commissioner like Mr. McMurphy, who's willing to take a stand and ask the oil companies to do what's right and have the counties get involved in that. I would point out that I think the county does have the right, and I think they've acted appropriately to the extent that they do have the authority to grant permits to allow people to cross their easements with lines. That doesn't give them the right to allow the use of another's, the landowners, the adjacent landowners, or actually they're not adjacent, but the landowner's property. As you all well know, the landowners in your respective rural areas own, in many times in your towns and cities and next to highways, absent a fee of simple ownership that's been granted specially to the Department of Transportation or something like that, owned to the center of the roadways. That's state law in Oklahoma. It's been upheld by the Supreme Court. It is well settled. And so each of you that owns land owns to the center of the section line roads. And you own it in fee simple, subject only to the easements that have been granted. The easements that have been granted in most instances in this regard are the statutory section line right-of-way, which the rights for the county to install the roads up and down the rural areas that we all use to access our farmhouses, our farms, our ranches. By way of background, my family actually has farmed and ranched in the Breckenridge, Oklahoma area. The home place is actually 4 miles north, 1 mile east of Breckenridge, between Garmer and Enid. I'm sure a lot of you are familiar with that area. I've had several sections and minerals, some of which the family still owns in those areas, and my uncle continued to farm up until recently when his health precluded that. So I am familiar with farming and ranching operations to some extent. I'm a city boy myself, but used to go spend the summers up on the farm, let Grandma and Grandpa make sure we knew how to work and handle cattle and chickens and all the things that come with that, harvest wheat, bale hay, haul hay, which I've hauled more than a few bales in my time. Anyway, so you own to the center of the roads. This issue is not new. If we look past the articles that are in here, first thing we've attached is a 1982 Attorney General's opinion, which was issued by Jan Eric Cartwright when he was our Attorney General. I actually worked in the Attorney General's office in 1978 into 1980 for Jan Eric Cartwright, but that was before this opinion was issued. And that opinion specifically, or the question asked at that time, and you heard Marcy previously indicate another AG opinion that she was personally involved in, having to deal with the oil industry, but this one specifically dealt with the placement of saltwater disposal lines on section line road right-of-ways, and whether the adjacent or abutting landowner had any right to have to consent to that, and whether any compensation was due. The Attorney General reasoned through this quite extensively for a couple of pages, looked at the existing case law at that time, and reached a conclusion that's set out on the last page of that, which basically is persuasive authority in Oklahoma. And the conclusions that the Attorney General reached were that a Board of County Commissioners may permit a private citizen to place a saltwater disposal pipeline in the right-of-way of a section line road pursuant to 69 OS Section 1401. That's one of the statutory sections, and that is correct. As I discussed a moment ago, I think Mr. McMurphy and a lot of the counties are doing this. They can grant permits for people to use that. That's only permission for them to be on the county's easement. It's not permission for them to be on the land owned by the landowner. Both are required, and this opinion addresses that. The second conclusion reached by the Attorney General in that opinion was that such an installation may not be made without the consent of the abutting property owner. Well, as we discussed, the Attorney General agrees with my opinion. In fact, part of my opinion is based on what he has written here and my analysis of the law. And the third conclusion that he wrote was the abutting property owner is entitled to be compensated for the additional servitude imposed upon his land in the event a saltwater disposal pipeline is permitted to be placed in the right-of-way of a section line road. So, the Attorney General, and this opinion has never been withdrawn or changed, is of the opinion that you, all as property owners, have the right to consent to a line being laid on your land, even if it is on the statutory right-of-way easement, section road easement, and that you're entitled to be compensated if someone wants to do that. Well, as we all know, that's not happening for the most part. I understand that it has happened in a few instances. I'm aware of a few instances, but in most cases, the lines are just being laid without any input from the landowners. Anyway, this was further addressed, if you look beyond in the packet, the next item, which is a Oklahoma Court of Civil Appeals opinion that dealt with waste lines. In this case, it was sewage lines that were going to be run in a housing addition to a house in the housing addition, but had to cross a couple of lots to get there that they did not own. And one in this case was from much more recently. It's a 2009 case, Oklahoma Civil Appeals number 10 from 2009. And the court looked at a very similar issue. It wasn't related to oil field activities, but it was pipelines. And these were waste lines because they were sewage lines, much like saltwater disposal lines would be a waste line, or lines that are or moving drilling mud, frack water, anything of that nature. There was a second argument in this case, which was that they were trying to acquire an easement by necessity. The court rejected both of those theories, and in particular rejected the thought that they had the right to get permission from the county to run lines across those lots and the statutory right-of-ways that went with some of the roadways that the county had accepted and was maintaining inside that housing addition. In doing so, it cited to the Attorney General's opinion and adopted that position. That's just been in the last decade. 2009 was only 5 years ago. There are other cases that are important in determining these rights or trying to sort out what these rights are. One of the factors that's involved is determining whether the activity is a private activity or a public activity, like a public utility is for the public benefit. Because section line roads, as I'm sure you all are well aware, can be used for the public benefit for like telephone lines, things of that nature. Common carriers can use the roadway easements to lay pipelines, cable lines, cable television, anything that's considered a public utility of that sort or for public purposes. The courts have addressed this to some extent and has addressed the issue of public versus private with regards to water lines. In another case that did not involve the roadway easements, but it involved the attempt to use condemnation procedures in a case called the Board of County Commissioners of Muskogee County versus Lowry. There were several companion cases to that. This case is a 2006 case that looked at whether condemnation procedures could be used to lay private water lines to an energy power generation plant. They attempted to use that it's a private power generation plant, the condemnation or the public need policies to get those lines laid. In this particular case, they agreed to also install a rural water district line for the rural water district, I think trying to bootstrap themselves into the position that they were somehow public purpose, even though it was a private entity that was laying these lines. In that particular case, the Supreme Court in Oklahoma found that that was purely a private activity, that they were not a common carrier, and so that these types of pipelines, in this case water lines, were not a public purpose. And so that's very important in extending the law and being consistent with the law here, and then we have a Supreme Court case. Anyway, that's kind of the background of the basic concepts and the some of the basic case law. There's lots of others that go to some of these same issues that we will ultimately argue. Anyway, we just wanted to provide you some background and show you some of the things that we're relying on in our lawsuit. The lawsuit is currently pending. We are in the course of preparing motions to file with the court to certify the class as a class action, which is our next step. We may do some additional discovery while we're doing that, but that's where we're headed, and hopefully headed in the next month or so in that direction to get that on file to try and get a class certified. What does that mean? What that means is that everybody that is similarly situated to our plaintiffs, that is landowners who have had these types of lines laid on their lands, will effectively be made parties to the lawsuit unless they opt out. Their rights will be adjudicated. We are seeking damages under several theories for that. The first and foremost is trespass. They basically have trespassed on your line. The Vertex case that's in the packet talks about the facts of that case basically being a trespass. And that's what we're relying upon here. They've trespassed on your property by running these lines. We're also seeking damages, obviously, for that. Damages to be set by the court. There are several theories that we're going to argue damages should be applicable to damages, and that should be used in determining what should be awarded. One of which is what's the value of an easement. Now, value of an easement is really only applicable if they're using condemnation, which they can't do in this case, or if it's a negotiated easement, which these are not negotiated easements, or we wouldn't all be here today, and we wouldn't have the lawsuit filed. What's the range that we've seen for these types of an easement? We've seen some running for as much as $100 to $180 a rod. Seen a few lower, seen some higher. I understand there's at least one agreement floating around out there that where a flat fee of $2,500 was paid for an easement. I'm not sure what the length of that easement is. We're going to investigate that further. An additional theory that we are going to pursue is one called unjust enrichment. The oil companies obviously have done this, or apparently have done this, to save money. They must have determined that it's less expensive to do this and run the risk that they're running than it is to bring the water in or to haul the fluids out in another manner, i.e. truck it, probably is their primary alternative. And so, due to the fact that they've trespassed upon these lands, we're going to ask that we receive funds for what's called unjust enrichment, that basically they've been allowed to save money on the backs of the landowners, and that the landowners should receive the money they paid because they're not on there with consent, they don't have permission, they are trespassing. So that's kind of some background and the basics of the lawsuit. Beyond that, we're interested to know what you all think. The attendance list that we've circulated. It's got a place to sign, phone numbers, addresses if you'd like to be contacted. We know there's a number of people who've expressed some interest in joining the lawsuit. If we get a class certified, everybody will effectively be brought in. If we don't, we will be subject to the plaintiffs that we have or the parties that might like to join in getting relief for the lines that have been laid on their property. I know in many instances the lines have been temporary and they were there for a period of time, 6 months, a year, 2 years, some period of time, and are now gone. We're going to be looking for people to provide stories of what's happened to them because of the lines, background on the lines, those sorts of things, so we can present some evidence to the court. We'd like to visit with anybody that's interested in those sorts of things or to participate with us in that regard. And we're here to answer any questions that you might have. So with that, rather than keep us here all evening.
My name's Sean Fulkerson. I'm Richard's partner. I do want y'all all to be mindful of, in this legislative session, Senate Bill 1812. It's a bill specifically targeted to fix and repair this issue in favor of the oil companies. And it's sponsored by, is it Marlatt? Marlatt and Jackson. So, in our opinion, this is an acknowledgement that there is good law and in our favor, and they're trying to fix it. So, I've got a copy of this if anybody would like to see it.
Can you explain what that's about? Did I misunderstand you?
Yes, I just had it handed to me, but basically it allows them to run these lines and do these things without compensating the landowner.
Without permission.
Without permission.
No permission from the landowner.
Yeah, that you give them a blanket
We're
right.
opposed to this then, right?
You bet.
Okay, what?
But it is an acknowledgement that what we're seeking and doing, they're trying to fix in the legislature.
Yes, sir.
If I might explain where I got this legislation. Can you hear me okay? I'm on the legislative committee of the Oklahoma NARO board, and our legal counsel and lobbyist, Terry Stowers with Burns and Stowers, texted me that he had just seen this legislation filed. Very concerned about it. Of course, all mineral owners and landowners would be. And I've talked to Randy about this quite a bit, and I do really thank you for all of your efforts. And I know you've taken some tough hits from this, but basically, I don't know why our senator has decided to go and be a co-sponsor of this. But basically it says any legal entity, I guess your neighbors would be a legal entity. Any legal entity doing business in this state has the right to put a power line along the side of your property or put a water line. And that water line could also carry salt water, which is being done right now in Alfalfa County. I don't know where else.
Power line thing too?
Yeah, power line too. And I will tell you that I'm totally against it. I think most landowners are against this. It does say that the oil company has to get permission from the appropriate county commissioners or the State Department of Transportation. Those are the authorities. You don't have any say in the matter. That's not fair. That's not right, in my opinion. I would urge all of you, I would beg you, get a hold of our Senator Marlatt. Lynn, get a hold of Mike Jackson over in Garfield County. Try to get this stopped. Try to get them to pull this if you can. It's not reasonable.
Did they write that legislation?
Yeah, well, somebody wrote it for them.
Did you know that senators can work for companies and be paid, and they don't have to report those earnings?
Does anyone, you people from Woodward County, do you know where our Senator Marlatt works?
Yeah. He's from Woodward,
Yeah.
and somehow
No, he's
this information needs to be put out to the people in Woodward County.
Can you do that?
I'll write a letter to the editor.
Okay.
This makes me very angry.
Well, it made me very angry too when I heard it. The best thing is to never let this see the light of day. Try to stop it right now. I thought he was working for an oil company over there.
When he got elected, he was actually selling cottonseed hulls and had a deal work in
Well,
the oil
that's,
field.
yeah, that's oil field related.
Yeah, I mean, it was an oil field related
Yeah.
business, and I don't know if that's changed, but
Well, that's oil field related too,
I
isn't it?
need to add something to this deal.
Go right ahead. I've said enough. Please
Well,
call.
just ACO, who's the Association of County Commissioners of Oklahoma, they're behind this deal too.
Why?
Because they think it's good for the oil companies. That's my big struggle. And you all need to think about your commissioners as they come up for re-election. Because that's why I'm the only one doing it, is because ACO is recommending that they don't do this. They're actually pushing the commissioners to work with the oil companies.
Our commissioner in Alphaba County, I talked to him about this, and he said, I tell them every time that they go across that road, that's just for the county. Any place else you go, you gotta see a farmer. And they don't pay any attention. I had a line that came out, laid it right across the field. And I couldn't find out where it was, who put it in there. So I just went over, checked out there wasn't any water in it, and cut it in two and got it back out in the road. And go back there a week or so later, and they put it right back in again. So I got trying to find out who it belonged to, and finally found out. And I called him, and it was that day when it was 5 degrees. And he said, "Oh well, we want to do everything we can. We don't." I said, "Well, you better have it out of there right away, or I'm going to cut it off again." And I thought, well, they won't do anything about it. That was on a Saturday. After church, I went by there, and they had it out in the road and around where it's supposed to go.
Right.
They got over there from Freedom. They got over there and fixed it where it's supposed to be. Now, they had no business to do that.
I do have a question. You made a comment a while ago. I'm under the impression, you said that condemnation wasn't part of this, that couldn't happen. I've been led to believe that it is, that they could do this with condemnation, but with condemnation, that there would have to be a fair market price paid for that. And the reason I believe that, and I need to hear why you don't, is because they do have the right to drill on people to explore their minerals where another party owns the surface and one party owns the minerals. So they've been granted that right of condemnation. And wouldn't that apply to these water lines also?
I think we've got a serious difference of opinion.
Condemnation goes to public purposes, and the right to drill on a section of land or quarter section of land, and I know most of the drilling and spacing units up in this area right now are full sections, I believe. There may be some exceptions to that. It doesn't create a public purpose. In fact, but for the Pooling Act in Oklahoma, you wouldn't even have the concept of correlative rights where the Corporation Commission can force all the owners basically to join together in a drilling and spacing unit and drill for the benefit of that group. And that serves a public purpose, but it's not the same kind of public purpose. I think the case that I mentioned that I didn't put in the packet goes to that issue to some extent, the one that dealt with the energy plant.
Well,
I mean, because energy plants are something that energy is being generated for public to a great extent, yet they weren't granted it, and that was a Supreme Court case here in Oklahoma. I think that they're reaching to try and find a public purpose. I will tell you, on similar issues in other states, it has been allowed, not in Oklahoma, as I cited the Attorney General's opinion in the case that's out there, and that there may be some rights to use public easements for transportation purposes. And some states that don't have the oil and gas industry like we do have reached conclusions that, well, whether it's in a truck or in a pipeline doesn't make much difference. But the law varies from state to state on that in the particulars. And in Oklahoma, the types of easements that are given and the limitations that currently exist on these easements, and I think some of what you're seeing is in that legislation to try and fix that problem. I don't think they would get very far with the condemnation action. Now, do I ultimately get to make that decision? No, the Supreme Court does. But I don't think there's a sufficient public purpose there. They're trying to generate a public purpose. But the mere fact that they've got a right to use somebody's land, that's common law. I mean, to use a term that you hardly hear in Oklahoma anymore, the rights of mineral owners in Oklahoma are what is called an incorporeal hereditament. I have trouble saying that once. I can never say it again. Which covers the right to be able to use the surface. The oil once severed, the minerals once severed, become a dominant state, and so they get some rights to use the surface as is necessary to exercise their rights to drill for, depending on the type of mineral, but in Oklahoma primarily oil and gas, to drill for and to produce the oil and gas. It could cover gravel or coal or others, but in Oklahoma it's primarily. You do see some coal down in southeast Oklahoma, McAllister, Pittsburgh County, that area. But
still, at the end of the day, in condemnation, they got to pay a fair market value.
At least in condemnation, they would have to pay a fair market value.
Your point's well taken. Either way, we're talking about fair compensation. We're not talking about, we want the oil industry to treat these plaintiffs fairly, not soak the oil companies. You folks all know that they do good things. The point is that they're doing these things without permission.
Without
acting
paying.
on people's rights. That's the point.
Well, I agree.
Yeah.
I mean, I'm not arguing the other way. I'm
Right.
just saying that either way,
Right.
they're supposed to pay a fair market value.
The point's well taken.
Is all I'm getting at. And there is one other thing I'd like to bring up that with ODOT involved and Bill, and I found this out. These permits became a deal patterned after ODOT, and that's Oklahoma Department of Transportation. The difference being is ODOT has right-of-way, counties have easement. ODOT owns from fence to fence, so they have the power to give a permit.
And they've purchased that right through condemnation.
Well, but my point being is I feel like as a commissioner, we're overstepping our power by issuing a permit that we don't have the right to do. Because all we have is an easement for public transportation and public utilities.
You want to take that, Richard?
There are significant differences between the DOT easements that they acquire through condemnation and the section line right-of-ways. The section line right-of-ways have existed as a matter of law since the beginning of town, 1907 statehood, and even prior to that in the federal patents. And I mean, we could get into a whole dissertation, and frankly, to get into that whole history, I'd have to think about it a little bit, probably go back and do a little more research. But it's existed forever. But those were imposed upon property owners by law without specific compensation for those easements at the time it was done. It's not like on that date at statehood or issuance of patents, they said, okay, you get this 160 acres, this quarter section, you're going to have an easement down two sides, so we're going to knock, either pay you for that easement or we're going to knock, $100 back then was a lot of money, $100 off the price because you are restricted. Some of your property will be restricted, or we will have a servitude. We have an easement that you're going to have to take into consideration in your own use. But the landowners here, I mean, you've got the right to use as much of that easement as you want, so long as it doesn't interfere with the county or the other public utility uses.
If you own along the highway, you don't.
There are differences. There are definitely differences.
I mean, I just wanted everybody to be clear on that.
Right.
And there is another thing. And that you didn't stress on, where you said, and by statute, as a commissioner, we can charge for road crossings. And that's a buried line. And that's set up by law. But the difference being and this is something everybody needs to keep in mind, when they bury a line down through here, they pay for 320 rods a mile. That's from the center of the section line to the next center of the section line. Now, if they've got to pay for that, why don't they have to pay for the lines down the road?
That makes sense to me.
I'm just making a point that maybe people can understand a little bit.
It's the same analogy.
And the statute that you are mentioning actually talks about those kinds of lines being buried, and there is nothing in there that really addresses specifically surface lines, which 99.99% of these are. They're buried, across driveways and a few odds and ends places, but other than that, they're pretty much laid willy-nilly on the surface, up against fences. Yeah, well, they are buried without permission, even when they do get buried. That is true. Anybody else? Yes, ma'am.
We had a similar situation in pretty much Woodward County with transmission lines for wind farms. And county commissioners giving private, not OG&E, but private wind farms easements that they were not supposed to be giving. And that took a while to kind of get that straightened out, but it happened. And they really run some people's land and cause a lot of problems.
Wind farms create a little different issue because most of those are owned and operated by public utility or public utility related entities, whether you get into some condemnation. We actually have just slightly been involved in had some discussions involvement with transmission lines from wind farms, and you're correct. It's a similar issue, but there's a lot of differences in those and what's going on here. We'll go up here. We'll come back to you. Yes, sir.
I've got kind of a legal question here. You referred here to the oil companies per site. I've been involved in 2 lawsuits on those water lines laid in bar ditches and collected both times, but not. The suit didn't target the oil company. The suit targeted the company the oil company hired per site. Now, if you're looking at a legal question, if the oil company is hiring this particular company to deliver that water, and they lay that line in that bar ditch, is it proper to go after the oil company or to go after the company that the oil company hired?
That's an excellent question. We have named, of course, Sandridge and Chesapeake to start with. We've also listed an additional group of additional, actually 1 through 100 of John Does for the purpose of adding any of those types of parties if we ultimately have to. We believe that all those subcontractors, if you will, that are doing that are doing it as agents of the oil companies. And if they try to go down that road, they're just going to try and shield themselves or hide from liability and put it off somewhere else. And we don't think they'll be successful doing that. But if we have to, we will add them as parties to this lawsuit with the court's permission, obviously, if we can get that done. Because of that potential issue. We've evaluated that issue, and it's a real issue, and we will have to deal with that. But I understand your question. I understand your concerns, and it's a point well taken. Because yes, most of the time it's a subsidiary of the oil company or another subcontractor they've paid to come in and do that. But I'm not. We don't believe that's going to shield the oil companies themselves because it's being done for their benefit, at their direction, at their request. Yes, sir.
On your lines, you were talking about those lines from the well. The way I understand it, the oil company has the right of way in that section to get their product out or whatever.
When you're dealing with lines that are on the same section as the well, the issues are different. Mostly what we've targeted here are those that go off lease or off drilling and spacing unit, because that is correct. The oil and gas rights are dominant. I know you all probably hate to hear that, but that's the term that's used to the surface estate, which is the subservient estate for those purposes. So they have the right to use whatever portions of the surface are reasonable and necessary in their operations. Of course, reasonable and necessary is certainly something that's different in the eye of each person. But they do have rights in that regards. Do they have to compensate for that? You can look at the Surface Damage Act. Did they pay for that at the time the well was drilled? If so, or the original agreement for surface damages the property owner entered into? A lot of those things could come into play on individual cases dealing with the leases or the drilling and spacing units. For that reason, that's not going to be something we can really address in a class action because everybody's rights may differ because of either what their agreement was with the oil company prior, or if they had to go the route of the Surface Damage Act and litigation to determine damages from the drilling of the well, et cetera, then what were the terms, what relief did they ask for, what rights did they ask for that was compensated in those cases. And so those are going to be such an individual thing. That's the kind of thing that class actions are not set up to handle. But with regards to once you get off lease and they just lay lines on everybody's pretty well similarly situated. They didn't have consent, they didn't pay for it. You don't have to worry, and it's all statutory right-of-way, county right-of-way easements, so you don't have to worry. I mean, there's not a lot of differences in each person's situation other than maybe things like, okay, it crosses 80 rods of my property, it crosses 100 rods of somebody else's, but those kind of things we can deal with. But the legal basis and the factual question, other than maybe the area affected, is pretty much the same for each landowner. Yes, sir, do you have a question?
What is the legal status on the closed section line as far as, the same thing as the regular open section line?
It would depend upon
Those lines across there?
if the section line is just not open, if there's just not a road there, but the easement continues to exist, then they wouldn't be treated any differently. If the section line has actually been closed, the easement vacated, then it's private property.
How do you find that out?
I mean, you'd have to go check the land records to see if anybody actually took a formal action to vacate an easement.
It's never been open.
There'd have to be a formal notice, and there would be in the land records a vacation specifically of that easement. If it's not there, then it's still in existence.
And the statutory right-of-way exists down every section line road in perpetuity unless vacated. So unless a specific action's been taken, necessary notice is given, and those sorts of things, then there's a procedure for doing that. So the rights would still be there. The county could come in and reopen that section line road, or somebody else. Yes, sir.
Have you had experience with power lines along the easements, not in or outside the producing unit, for the purpose of powering these submersible pumps in wells?
I have not. Now, I would think that the same logic would apply if it's a private line being run. If it's the co-op line being run to the lease and they're just coming in to tie into the pole set by the co-op, or I guess it's probably co-op in most of your rural areas, and it's on lease, then it would be covered by their rights to use the portion of the service that's reasonable and necessary. But if they are running their own private lines down the roadway, then I would think that a similar logic would apply. I haven't really researched that specific to electric lines, but that once again would be a private use, not a public use, if it's just for a single owner or oil company. Even if they were running it to 2 or 3 consecutive sections where they have wells, they're still the only ones tying into that line. It's their private line.
Seems to be a difference in our area between the way REC handles that and the way OG&E's handling it. REC sells electricity to the oil company purchasers, and the oil companies build the lines and have all of the infrastructure put in place and just buy the electricity. It appears that OG&E claims to have the lines built and they're paid for over the term of the purchase contract with the oil company, but then they own the lines, so they want to be treated differently.
I'd have to look into the particulars of any of those circumstances, but it's not unusual for an electric company to run a line and whoever it's being run to pay for it, and it's still effectively a public line. And what that matters is, the others could tie into that.
They should pay damages, should they not?
If it's on an existing right of way, they wouldn't have to pay additional. But if it's off of an existing right of way, yes.
Well, I'll get a little more pointed. I'm familiar with the deal where an oil company hired a contractor to build a line where there was no existing right of way and there was no condemnation. There was no legal action taken. They just built the line and started transmitting electricity across.
Was it on the drilling and spacing unit where the well was located?
No, it was not.
Was not.
It's currently under appeal to the Court of Appeals.
Okay, I was going to say I would tend to believe that was not appropriate without having researched it further, but I agree with that position that they should be compensated. Off the top of my head, without looking specifically into that. Yes, sir.
Back to the deal of a well in a section. Say there's 4 different owners. You say they run this line around that section on the outside of the fence in the county easement. Is that like what Rick asked a minute ago? Is that the same circumstances there? That well is going to tie.
Well, you're saying you have 4 surface owners, maybe each owning a quarter section?
Yeah.
Presumably the well's all in one quarter section, tank batteries all in one quarter section. Well, if they've only reached a surface damage agreement with that party, then the potential is there to ask for damages for any lines that leave that quarter section or whatever area has been covered by that surface damage agreement with that owner.
The other landowners would fall under your suit.
That's correct.
Okay.
That's my initial thought is.
Well, I mean, that's not.
Well, it would be a little different. Well, it wouldn't be quite exactly the same because they do have a common law right to be there, so it's not a trespass issue. It's just a damage issue. So there are some differences.
It's not trespass, though.
It's not trespass because they have the right to be there. Now they may have to compensate for any damage or what they have to do there, but they do have a right under the oil and gas leases to be on the section or the area included in the drilling and spacing unit or the leases if they've been pooled in a drilling and spacing unit.
Even if one of the owners of the 160 acres just owns surface?
Even if they just own surface. The rights of the oil company to reasonably use the surface is still there. But there would still be a damage issue that attaches to that. But it wouldn't be quite the same as the others because there's not the trespass because they do have a right to be there.
So you're saying if they lease and there's some others, you have the owner, they get the surface damages, but the others don't come into that. Am I understanding correctly?
That's correct. I mean, if they're going to use different surface owners' property in their operations, then they should compensate each one of those.
If you don't get one thing from tonight, this bill right here is very important. Whichever side you're on, no matter what you believe, read this, look at it. If you're a landowner, this should be shocking to you. And it's really going to address what we're trying to address in this lawsuit. They're trying to fix it. They know there's a problem. And so we will be happy to send you a copy of this. If you will give Angela in the back your email address, we will have it emailed to you because it's that important that you have this and that you read this. And that if you believe that this is wrong, you need to contact the folks that are sponsoring this for Big Oil.
Absolutely. If you want to, that sheet we sent around, if you haven't signed it, just add your email to it, it'd be perfect.
You just send them back around. Anybody wants to add their email, they can.
If you have specific questions of things that we were unable to cover here, send us an email. We'll respond to you. We're going to be involved in this thing. We believe in this thing. Like I said, this is nothing about sticking big oil. It's about what's right and being fairly compensated for rights that they're using in your property. That's what it's about. Nothing more, nothing less.
In an earlier life, I used to work for the Oklahoma State Senate, so I'm going to make some inquiries about this quickly.
You have a question over here, Rick?
You mentioned
Yes, sir.
trespass. These people laying these lines, they come out and stake the line across your place and have never talked to you. That's trespass, isn't it?
That is.
So I have the right to go pull up their stakes.
Yeah, if it's not on the lease or
Pickup full.
if it's not related.
If they sue you, I'll come represent you.
You're on share in the whole gas lease. It's on your property.
No, they were just,
Going across you from outside.
yeah.
That's it.
That's
what I'm
yeah. I was going to say if it's
My son put it right across the hayfield, never said a word about it.
if
When I
it's
saw it, I decided to get it up before they start digging.
if it involves production on your property or in the drilling and spacing unit, they would have a right to be there. Compensation becomes another issue. But if it's off the lease or drilling and spacing unit, then they got no rights to be there. There are some rights for seismic and some things, but that they still have to compensate you even for running seismic. I'm sure there's been a lot of seismic shot up in this area off and on or in the past.
That blanket, right.
And
You know, yes, sir.
There's gonna be several wells you're able to drive around in my neighborhood, and the water is pretty hard to find right around there, so there's gonna be a lot of lines laid in ditches. And, well, I've tried to argue with them before, but I didn't get anywhere. I didn't know how to go about it, really. But once this starts, and it's gonna start pretty quick, and they start throwing those pipes down in those ditches and snapping them together, from that point, what do I do?
Well, you can do nothing. And if we get certified, you'll join the class and would receive compensation if we're successful in obtaining compensation. Or in your individual circumstance, if you wanted, you could seek relief in an individual case and ask for an injunction to stop them from installing and maintaining those lines there.
But that would take a specific action filed in your name with the right and go forth in court to get a judge to sign an injunction to stop them from doing it.
What if this law passes, how does that affect your case?
Any change in the law now will be prospective. They can't change your rights retroactively, particularly property rights.
They can't fix what's already been done, in other words.
Yeah, but going forward.
But going forward, it's a whole different ballgame.
Well, except that, well, there might be some issue going forward if they are changing your property rights. I mean, there are constitutional provisions that say they can't take your property without due process of law and compensation. And so if they're significantly impacting rights, they might give rise to a whole other lawsuit by somebody to either overturn the legislation or to seek damages on behalf of people because of those changes. But that's a whole different ballgame. Yes, ma'am.
At what point could someone join in this lawsuit?
You can join with us at any time. Anybody that would like to get with us, we're willing to visit with you about that. We're probably going to limit to the plaintiffs we have here, at least named, because otherwise we keep having to amend this thing, and every time we change it, it slows things down. We're at the point now we're trying to just move this thing forward, and if we're successful, then if we're not successful certifying a class, anybody and other clients that we have that are not specifically listed here will be joined as specific plaintiffs to try and obtain individual relief for them. But we're real hopeful that we'll get a class certified.
The lawyer's fees would be spread out among the plaintiffs.
That's correct.
Great question.
And-
Spread out for successful recovery. If we make no recovery, then there would be no fee.
Okay.
It's that type of case
Good.
where we believe in it enough to where we're not asking you to pay us up front.
And the causes of action we brought are also, we believe, attorney's fees cases. I don't know if you know the law in Oklahoma and most of the United States is what they call the American rule, is that winners and losers in lawsuits don't get attorney's fees unless the statutes or the law somewhere specifically provides for it. And trespass, and in this instance, does provide for that. So one of the things we'll be seeking, if we prevail, will be compensation for the attorney's fees the parties are incurring.
The point I was making to this gentleman, if he filed his own personal lawsuit, he's going to have some major law fees.
That's true. I mean, anybody filing an individual lawsuit will have to bear the fees, in that case, their own, whether it's on a contingency, which there'd be no fees if no recovery, or if it's on an hourly basis or some mixed type fee case or flat fee or whatever, they would have to bear their own cost if they don't prevail and if the court doesn't award attorney's fees.
So what Richard's saying is that if you prevail, let's say that he files his case, and if he prevails at the end, and it's an injunction or a trespass case, there is statutory law that allows for the other side, the losing party, i.e. in this case would be the oil company, would pay the attorney's fees and reasonable costs associated with prosecuting that claim.
And in that instance, like this gentleman said, you may join or go after in significant part the contractor, the subsidiary, whoever is also actually installing the lines, participating in that.
On this same deal, election time is coming up. Our district attorney.
Do we want to take a vote today?
Is not.
No.
Our district attorney is not running. He's retired. He's over 5 counties here. Can a district attorney take a different opinion to this? Ours today sees this as civil trespass. I mean, can there be a difference in opinion of the trespass be criminal instead of civil?
There can be. My guess is it's not politically expedient to pursue criminal trespass. And if the law gets absolutely settled in a case, I mean, it's pretty strong right now, then I think a DA might tend to make a look towards criminal trespass. But, we see that not only in this area, but a lot of areas of law. If the DA thinks there's a civil remedy and you can go pursue that, they often tell us, go chase your civil. We don't want to get involved in, minor stuff or white-collar stuff or they like to get murderers, rapists, and,
Well, I was just, this deal's came up.
Right.
But
really, the worker that's out there would have to be charged with a crime. The corporation's the one that's doing this, not the individual. The guy that's out there working is just a guy doing what he's supposed to be, what the company tells him to do. He's not. And so that wouldn't be a real good,
that's a good point.
stance for a district attorney to take. And you can't charge, the corporation. So I would think that they would not be willing to do that, in my opinion.
I was just curious.
that's a good point. There's some practicalities that play in, or some realities that play into that about that. Yes, sir.
I got a question. We're concerned about all this water being polluted and earthquakes and sinkholes. My question is there anybody trying to oppose the oil companies to come in, and you don't have a choice? You either sign up or they fool you. Is there anybody concerned other than...
There are environmental groups that are concerned about, in particular, you're talking about the fracking issues, the nature of the chemicals and the pressures they're now using, and the more extensive size of the well bores now that they're horizontal and not just vertical. I mean, there's all sorts of things that play into that. And of course, whether that's causing or contributing to these earthquakes, whether saltwater disposal for the last 100 years has contributed to those earthquakes. About the only ones I see opposing that are environmental groups, which are not really getting a lot of traction at this point. We continue to have earthquakes. I think you're going to see more public displeasure with that. We've had a number of earthquakes in Oklahoma City or the Edmond area, Stillwater, Guthrie, Langston.
Is nobody concerned about the copious amounts of water that they're using for this process?
And that's another good issue is they're using lots of water, and the water often is lost. Where
the Oklahoma Water Resources Board who has jurisdiction over that, and they need a public forum to do that. To my knowledge, they have not provided.
They've never helped us.
Yes, and that's the agency that's charged with that authority, and they need to be involved with that. I mean, Richard's you wrote the DEQ law and some of that stuff. I mean, isn't that who has jurisdiction?
The Water Resources Board has jurisdiction over the granting of water rights. The water they're pulling for rivers, any rivers, surface waters, waters they're getting from wells, groundwater. I mean, the permits are required for that if it's being used for commercial purposes. Any limitations you would see put on that would have to come from the Water Resources Board. And right now, the law is fairly broad, gives them broad discretion to grant these permits, and there's nothing there to really hold the oil companies always accountable for that.
And another
to the extent that a lot of people would like, because you're right. I mean, water is a strong. It's the important resource in this area. I mean, it's the Ogallala aquifer back up in northwest Oklahoma has been declining for years and years and years. We've seen that in other aquifers. I've got a boat on a lake that, right now is sitting on the bottom of the lake because the water levels are so low in the lake that my boat's sitting on. So I won't be doing much boating, fishing, or anything else unless the rains come. Yes, sir. Did that answer your question? I mean, did that help?
I got one other question.
Sure.
we've been trying to find from the Corporation Commission or whoever, what the rules and regulations concerning this fracking. And we get the general runaround on that.
If you'll give us your email, we can obtain and send you a copy of the
Or your address. We can
or your address. We can send, let us know, make a note somewhere and give that to us. We can get you what the rules are. They're not real extensive. I can tell you that. I mean, fracking's been going on forever. I mean, it actually has, but now it's become more prolific. It's become higher pressure, and they're using different chemicals. And then, of course, the whole purpose of fracking is to open up well bores to treat well bores to get more oil to flow to the bores so they can be produced. But I mean, a form of fracking has been going on for a long time. They used to use primarily sand and some chemicals, and you know, the nature of the materials they're using have changed. The pressures at which they do it have changed dramatically over the years as technologies. I started to say improved as technology has changed. I mean, much like we can now drill these large horizontal wells, when I used to see, you know, they had difficulty directionally drilling vertical wells. They just wanted to directionally drill them a little bit and keeping them on track to end up exactly where they wanted. Now they take these things down, and it's amazing what they can do.
Be mindful that these wells, these horizontal wells, are exempt from gross production tax. So the roads, the schools, they're not paying.
They're paying 1%.
Very little.
Until next year.
Very little.
1% until next year, then it goes back to 7%.
Of course, they're trying to. There's an effort being made to change that also.
Absolutely.
Well, of course, we mineral owners don't like that 1%.
Sure.
Yes, sir.
Okay, on your water resources board, what about these people that sell water out of the river? And there's people on both sides, or they suck out the south side of the river, and nobody gets compensated on the north side during the next quarter, east and west from there.
Individual landowners, riparian landowners that abut a river, what's called a navigable water, basically, but it's almost any river stream of substance, can obtain rights to take so much water out of that river, and they don't have to compensate anybody else for what they take. And as we said before, the oil companies get a piece of the surface rights, if you will, to use the rights associated with the tract of land. So the oil company's got some rights there to potentially use water also. The first case on that, name escapes me, God, it was 30 years ago, dealt with a water well. The oil company went and drilled a water well to use for drilling purposes. And the landowner got all upset and sued and won. And then on appeal, the court said, well, you know, they got a right to use whatever portion of the surface is reasonable and necessary. And I mean, the water rights basically are part of the surface, if you will. So they got a right to use whatever is reasonable and necessary in their operations, including water.
What about if it's in a different section?
The landowner abutting the river, if it's off lease, basically, the landowner abutting the river would have the right to make application to take water out of the river. And to the extent that that permit's granted, they can take water and use it to sell to an oil company or do whatever with it. The oil company might have rights, if their lease is adjacent to the river, so it's basically part of the riparian surface there. You're going to make me think about water law. I didn't come prepared to talk about water law today. But we can talk about that. I'm somewhat familiar. Having.
If they don't get the water, don't apply for the permit.
Well, nothing happens unless somebody does something to stop them.
And that's at the Oklahoma Water Resources Board.
Right. Those permits are from the Oklahoma Water Resources Board.
Any particular individual in the Water Resources Board that's the best
There's a
to
division.
contact?
There's a division. If you'll go to the website for the Oklahoma Water Resources Board, there's a permit division, and then they'll get you in regard to oil and gas activities.
You can look that up, or we could look that up for you. I'm sitting here trying to think. Some of the people I knew at the Water Resources Board have left, and so I hate to give you a name. They may not be there anymore. I'd have to double check.
Don't you all wish you had read it in Murphy Hours, and he is up for re-election this year. Not this year, next year. Okay, what about?
Is that no this year and next year? Or is that just no this year?
No, this year. I was 2 more years.
Oh, I was going to say.
I'm on District 2.
Okay.
What about Bryce?
He cannot be, he's term limited.
Is he this year?
So he doesn't care what he is.
I know.
Well, he hadn't been there 12 years.
I don't think he's got another.
I think the most important landowner here just entered the room. Future landowner.
Because he got elected after me, and I was there 6 years.
Right.
I have one question. Have any of you ever been approached by one of the oil companies to compensate you for using your land, or have you entered any contracts with those oil companies for using your land for these lines?
Well, I can say that I've been compensated for the use of the land for power lines.
Right. Okay.
And I've also been not compensated.
Yep.
I believe the law is it was used for oil and gas purpose, which I consider private purpose. The abutting landowner should be compensated.
They should almost always be compensated for putting the lines there. The question of whether they have a right to put those lines there is typically for oil and gas. That's not correct unless you get into a situation where you're dealing with a transportation line. It's a common carrier. They're running lines to a compression station, a transportation line. If there's no more general questions, we're more than happy to stay around and visit. Yes, sir.
What's the average compensation per rod you're talking about here? The land water line on top there.
We've seen paid and had a client paid recently, an unrelated matter. $180, $160 a rod. We've seen $100 to $180 a rod. Like I said, I understand there's a blanket $2,500 agreement floating around that we're going to try and get a hold of. It's referenced in one of the newspaper articles.
That's how they're paying to put underground.
Well, I think sometimes by the time they get around to paying these things, they realize that they've done wrong and they're trying to make it right. But, I don't know. It's one of the things we're going to have to investigate further is what's being paid for similar lines in this area. But, the bottom line is ultimately if you don't want the line there, no amount of money is enough money.
I think they've been paying, at least where I am, they've been paying for these high lines all right.
That's not good. They need to pay when they run these sorts of things.
The oil companies are just themselves.
Why is it above ground and more of a nuisance than one's below?
There's a lot of truth there. And sometimes since they're temporary, they'll pay more just to get it out of the way and get done. Yes.
I have Bryce Marlette's telephone number, if you want to write it down and call him tomorrow. This is his office number. And I thought, I just told him I went to a meeting with about 60 royalty owners, 4 lawyers, a newspaper, a bunch of other people. And
they're mad as heck.
we do not want him to go any further with Senate Bill 1812. Here's his telephone number, 405-521-5626. That's his office. Please repeat. 405-521-5626.
Thank you. What's the number of the case?
Senate Bill 1812.
If there's not any more general questions, we're more than willing to hang around and answer. Okay, we got a couple.
Has there been any damages, salt water from these lines on anyone's property that you know of?
I know there's been some broken lines. I can't give you a specific example.
I've had an issue for 6 years on saltwater lines, one of which was buried. 3 others, they left them on top of the ground, not buried, for about a year and a half, which the commission just said was not reasonable and not ethical. And I've been 6 years trying to get compensation and get the remediation done, and I still haven't got it done. I've got
Saltwater damage?
saltwater damage to the wheat fields.
Well, you need somebody to help you
Well,
kick tail.
I've had
Oh,
Mahaffey and Gore working on it.
okay.
And,
I know Greg Mahaffey
Commission's been working on
and
it,
Mr. Gore.
And it's just
Who's the attorney over at Mahaffey working on that? Travis
Cody
or Greg?
McPherson and Greg
Yeah.
Mahaffey, Cody McPherson. And we got
They gotta pay this, you know, they're up there, run one line, a year later they run another line from 2 miles away. Is this a one-time deal?
They should pay for each line unless they get a blanket easement from you or something like that.
Each use should be
Each use should be separate.
we've been doing multiple lines.
Basically, how long do they leave those lines in place?
Well, most of the ones that are on the surface running down the section line roads, to my knowledge, are temporary lines and are 1 year or less, though I understand some have been out there at least for a couple of years. I think they've had a tendency to use one line for one well and then extend it out somewhere else to use for another, and so they stay there. Though it's a temporary line, it kind of becomes temporary for this purpose and then becomes temporary for a different purpose.
Are they going to the disposal wells? Is that what they're doing with the
I think they're going to disposal wells, or they're going to sites where they're accumulating fluids to be disposed of, or their water lines bringing water in. They're being used for multiple purposes, or different purposes, depending on the need at that location, for that well.
I would like to mention one more thing. I think there are quite a few people here who have not paid dues to the Woodcutting Mineral Owners Association. Now, while these guys came, no payment to them, we didn't even take them to dinner.
But let's thank you for coming out.
Thank you.